Surely. Let's just go into sort of major themes, because obviously he's been on the court since 1971, so there's a lot of cases, and I don't think the audience is interested in specific cases, is what is the general theme. Essentially, on sex discrimination law, his opinion is that as long as the state, that's a local government, state government, or the national, has a reason for sex discrimination, it's okay. Even if the reason is concocted after the legislation is passed or just for the court case. In other words, he has not a very high standard in rejecting sex discrimination. Most of the jurists on the court have a position that if there's sex discrimination, there really you have to look at that very carefully, and unless there is some compelling, or they call it a strict reason, a strict scrutiny, you should reject it. And so essentially what the effect is, he lets stand a lot of laws that discriminate against women, and it has real impact. Well, obviously, we think that it's uphill, but not just because it's a presidential nomination. Let's face it, the president really doesn't have the right just to name a person like he would in his cabinet. These are lifetime appointments. So essentially, the Senate has a larger role, and their confirmation shouldn't be a rubber stamp, and as several of the senators on the Judiciary Committee said that. I mean, what we're about to do and what they're about to do in this period is name a person who could well serve as the head of the judiciary of our country well into the 21st century. So it should have real strict scrutiny, and for that we think we have some chance. But let's put it this way, you know, you don't enter these things just as on sure bets. You enter them because you must, and you don't want to have to do something like this, and we've not done it often. I mean, one of the reasons why we think the public should take so seriously what we're doing and imposing is that the major groups who are doing it, and it's all the major civil rights groups and women's rights groups, have not done this very often. We've only opposed very few appointments because we know that in essence the president and has some prerogatives, but on something like this that is going to last for so long before, after Mr. Reagan, and when you have nominated the person on the court that holds the most extreme views against women's rights and civil rights, we think we must speak. No, I've never have, but we're obviously, we don't take a knee-jerk reaction. We do believe that in shelters. We also believe that women have rights, but we are people who believe in due process too. I don't know what her point was, but God knows the women's movement has worked very hard in the area of trying to reduce violence towards people. Well, it depends on the area. I mean, obviously we're a volunteer group, and it depends on the chapter, and we do have a lot of volunteer lawyers and pro bono people, but not in all areas. And so I can't, say that unequivocally. I don't know where she is. I don't know what our resources would be there. Well, his viewpoints on women's rights, we feel, are not what they should be, but really this is not an issue of Mr. Reagan right now. What this is about is the head of the third branch of our government. And what should be at issue here is the record of Mr. Rehnquist. And what we will be doing before the Judiciary Committee in very strong testimony is reviewing cases and his decisions. And we want the record to speak for itself. We want people to not judge on what Mr. Reagan viewpoints are or popularity. It's what this man is going to be as Chief Justice of the Supreme Court. Well, not only would I not agree with it, I don't think Mr. Rehnquist would agree with it. As a matter of fact, in my testimony, I think it was also alluded to today in the opening of his hearing, he has written in Law Review, in a Law Review Journal article, that he thinks that the justices to the Supreme Court should be reviewed very carefully, because indeed they interpret the law, and on areas of equal protection, and of due process under the law, which is the 14th Amendment and one of the most important areas of our whole law for individual rights. He says the only way that you should review these cases is to know what the man thinks, or the woman. Too often it's been obviously all but one time in history men, and that if people, the senators, have a right to not only ask what they think, but to make the judgment on that. Because in fact, how would you have change in the court or keep, up with the times, unless indeed the justices reflect the opinion of what should be, in my opinion, in this case, the consensus of our country for civil rights and for women's rights, especially, when you're talking about justices to the Supreme Court. They are the final say. There is no reprieve. This is the highest law of the land. And so no, I don't think that one president's appointments, just because he says so, should not be reviewed. And in fact, they have been in the past, and they've been rejected. And the conservatives rejected, and under Johnston, Abe Fortas simply because of ideology. So they can't complain today. This is the premise that they've already rejected a nominee. Well, there's no question that the United States Senate is not representative of, let's face it, it has no blacks, he's right. It has only 2 female members. That's right. And I just hope that in this case they are very, very careful. Because on the issues of civil rights, I don't think any of us want to go back to have to live all those fights on segregation and on due process for blacks again. I just don't think that we want to go through that pace again. I think the country has said that they want their justices to be committed to equal rights for all. And I don't think that this nomination meets that test. I think that we already have some listening. I don't know if we're going to win. What the papers say is, of course, not. But let's face it, they've been wrong before. One of the people who was leading the opposition to this nomination is a man named Joe Rao. He's one of the deans of the lawyers here in town. He led the fight against 2 justices nominated in the early 70s, Carswell and Hainsworth, or late 60s, that is. And both of those men were defeated on their civil rights records. So we think that, everybody said they were shoo-ins at the time. I think that one has to look at this record and again. I mean, it would be much easier for us to be here saying, hey, this is terrific. It's hard to fight something, especially when you know that there's probably a majority. But I firmly believe that there are times in history that people think in the long view. And you just got to question whether a person who has a very limited notion, in fact, he keeps talking about the framers and what they intended. Well, the framers did not see, an equal role for women or for blacks. Let's face reality. And he I think, narrowly interprets the corrective laws. In other words, we've now put laws on the books to correct some of the inequities of the past. But he narrowly interprets it. He limits opportunities. He says he's a strict constructionist. We think we can show that he is an activist. I'll give you some examples. In the area of pregnancy and work or employment, his viewpoints are such that pregnant women could be fired, that the laws can be structured so that the state can pretty much not eliminate their guarantees. We think that pregnancy should not be used as an excuse to fire people, that they should get leave, that in fact they have seniority rights, women who are pregnant and must leave for a baby and come back. We think that battle has been fought and won. We think we have, and we know we have anti-discrimination acts on the books. He has chosen to interpret them narrowly and has led in the court in that area. our feeling is that this is in no way a viewpoint that should be at the highest viewpoint. Okay, yeah, I agree with you. I don't think it's a foregone conclusion. In fact, I think votes are very open, and I think there are many questions. On the 14th Amendment, that's one of the civil rights after the Civil War amendments, which has an equal protection clause and a due process clause. It is in that amendment is the basis of anti-discrimination laws in our country, and it is the basis, really, frankly, for women's rights and for civil rights for minorities. His career, Rehnquist's career in this, begins very early. It begins as a law clerk under Justice Jackson, where he writes a memo, which he says he did it as sort of the devil's advocate. In other words, that it wasn't his belief, but which he essentially questions whether the segregation rules of a precedent called Plessy versus Ferguson should be overturned. In Brown versus the Board of Education, it was overturned. He says he now supports it, but this memo and a series of memos as a law clerk when he was 27 years old indicates to many that he really wasn't for striking it down. Well, whether he was or not, and you'll hear a lot of Republicans and a lot of people saying, and I don't think incidentally party matters here, so I shouldn't have said Republicans, but you'll hear some people saying, well, it isn't fair to pull out a memo that he wrote when he was 27 years old. But that being the case, because I do think it is fair, it indicates where a person is, but forget that memo. So let's see what he's done since. And what he tends to do is constantly rule in the most narrow sense against minority rights. Give you a living example. He was the lone dissent in what is called the Bob Jones case, where Bob Jones University practiced a form of segregation on the basis of race, and they wanted to maintain their tax-exempt status and still practice it. He ruled for Bob Jones University, the only one out of the 9 people. Again, it is just a constant interpretation that narrows the application of the equal protection and due process clauses of that amendment. And in many cases, both for women's rights and in civil rights, he is consistently for the narrowest individual rights, much more for property rights, and much more against breaking down the barriers of discrimination. Sure, on the first part on strict scrutiny and what's the difference between civil rights for blacks and women's rights, the standard under the law is stronger to eliminate race discrimination than sex discrimination. Race is considered a suspect class. What that means is if in a law race is a factor or in a program, it's always suspected to be discriminatory. In other words, in the eyes of the law, it is usually wrong unless there's some overwhelming. It's suspect instantly because we fought a civil war over this. We said there wasn't going to be race discrimination, and that wasn't just a civil war. We overturned in Brown versus Board of Education any type of vestige of segregation, and so there's a huge set of precedents in the Civil Rights Act and a large number of cases. We have a consensus that race discrimination is wrong. For sex discrimination, that consensus has not been as strong, and I wish it was. That's why we want an Equal Rights Amendment. But sex is not considered a suspect class under the 14th Amendment as race is. What does that mean? It is not instantly suspected as wrong that there is a treatment in the law that treats men differently than women. And what now we have is what's called a strict scrutiny standard. In other words, if there is a difference in the law or a program on the basis of sex, you really should scrutinize that and be very careful that this isn't discriminatory and just hurtful and it has no reason at all. In other words, now he wants to lower that standard to just a rational standard. Any reason will do. Just any reason. If the state wants to put out anything, you concoct any excuse, it's okay. Because after all, it's reasonable to discriminate on the basis of sex. So essentially, under the law, we don't have a suspect class, but we have strict scrutiny for sex. And Mr. Rehnquist, if he would be the dominant view, would lower that, so that really, frankly, sex discrimination, anything goes. For sure, we would need an ERA. We need one anyway, but this would just, it would be impossible. Essentially, he would reverse much of the precedents for women under the court. Now, do we often oppose jurists? No. Chief Justices, no. As a matter of fact, as I pointed out in our press conference yesterday, the last time I testified on a justice myself, and I've been off and on the president since 1977, I testified for Sandra Day O'Connor. We're not in a knee-jerk position. We're not opposing him because he's a Republican. We're not opposing him because he is supposedly conservative. I say supposedly because I don't believe he's conservative. I believe he's reactionary. He would change the status quo and drive us to a time of yesteryear for women's rights and civil rights. Not very many, except that, as I said, Abe Forrest was put forth. He was rejected. He was also sitting justice. In fact, I think I saw a review where when presidents put forth sitting justices for the Chief Justice position, their batting average isn't as good as when they take them from off the court. I think it's because their records are so clear then. But anyway, I can remember Carswell and Hainsworth in recent memory, and there's others, obviously. Well, let me just address that head on. As you know, in our press conference, who led it was Benjamin Hooks and the NAACP and the NAACP Legal Defense Fund. I'm not sure they even have a position on abortion. A lot of the groups in the Leadership Conference on Civil Rights do not have positions on abortion. Now, we do, and we are concerned with his viewpoints on right to privacy. There is no question. We think his viewpoints on right to privacy are quite extreme and would put in jeopardy, if it was indeed all these decisions reversed, not only abortion but birth control itself. But that is by far only one aspect. And if you could, this voice, and I don't know the race of the caller, but is the most extreme voice against affirmative action, civil rights, and women's rights in general. And of course, has an opposition position on abortion. But you would not see this consensus of opposition from the civil rights and women's rights community across the board on this appointment if it was not broader than that. I happen to think that this issue itself is very, very important, but it is only one aspect in the whole, syndrome of his viewpoints. Well, I think he's right, that you have to review the whole record. And that's why I'm saying that we know, he has written opinions for 14 years, and I think that on the balance, that this record is what it's what we're so upset about. We find it frightening. Well, what is the purpose of a confirmation hearing except to review and to scrutinize the appointment? What in the world is this about? Is this to be a total rubber stamp, or do we have an obligation to review it? And we're doing it in a dignified manner. Any person that is seeking such a high position should have to meet some test of scrutiny, and that's the reality. Now, sure, every public official today has to go through a lot, in reality. All of us in some ways or another. But I think if it's done with dignity and we really do look at the record, and you'll see our own testimony and the testimony of the groups that are opposing it, we will do it in a manner that tries to put forth exactly what is that issue to people who should study the record before they vote. And as far as I'm concerned, the United States senators who are voting on this is one of the most important decisions they're going to make. And I hope that they realize how long and how important it will be for history, and that they do it on the basis of study. Well, sure. The one thing his comments made me think of is one of Rehnquist's views about the minority rights and majorities. Essentially, what he has said in so many words and in writing is that the minority's rights are what the majority deems them to be. In other words, he sort of believes, and he does believe, that the majority has just sway, they can do just about anything as long as they got the majority of the votes. Well, that is not the concept of our government. Our government has guaranteed certain rights to people. I mean, remember, we are the country of those who came from religious persecution. So small religious groups came, and they knew that they had fundamental guarantees, that the majority couldn't just wipe away their rights. And I really feel strongly that his concept of essentially whatever the majority thinks goes is absolutely not in keeping with the entire history of our country's guarantees for minorities. And I'm not just talking racial minorities now, I'm talking about any grouping of people. We've given certain guarantees to individuals, and the state just can't do anything it wants to. In other words, he sort of views that the state has unlimited rights instead of having the government be limited by the Constitution and the Supreme Court use the Constitution as a guide and as giving individuals guarantees against government extremes. He sees it as the government, if they got the majority, has their rights to really do what they want. So he constantly rules for the state legislation or state regulations or that limit individual rights. And it goes on and on, a whole host of cases. And I sometimes think when we just talk race and women, people don't realize that this goes into freedom of speech questions, this goes into individual privacy questions, this goes into a larger range of individual freedoms. Well, the fellow that just called in just doesn't have some of the facts right. We have on the issues of ending sex discrimination, a majority of both men and women in this country, especially in the issues of equal educational opportunity, equal employment opportunity, pay equity. The numbers are overwhelming for support. In fact, 57% of all women, according to a Newsweek poll, and you can't hardly call that a feminist journal, say that they consider themselves feminists. So, but what we're talking about goes beyond women's rights. It goes to individual rights as a whole, and we're not really talking about this as personalities. We're not reducing this into a personality contest. This is talking about a person's beliefs under the law, and we think that his beliefs, as written in his judicial opinions, fall short of what we think that the average American citizen should be guaranteed. Yeah, our group does not feel expert in this, but I do know what I only read in the paper, but what other people feel about it, so let me just review it. Essentially, the question is, did he, in the 60s, lead a ballot security team for Republicans in which they went up to black voters, or potential black voters, and questioned their literacy. In other words, it was in a time when you would knock out people because they couldn't read or write. And so, but it was done in a very harassing way so that you would discourage the person from voting and drop them out of voting because you felt that person wasn't with you. Essentially, Rehnquist denies that he was a part of this effort himself personally, although he had some role in this whole thing. He was not one of these people who personally challenged, according to what he says. There are people, I believe, who will testify or who have been quoted in the newspapers at least as saying that they saw him in this role. And the question here again, though, and again, what's an incident that takes place some years ago, what's it mean for this, is really what his views are on voters' rights, what his views are on the minority question, and what is there a credibility here when 12 people or 5 people, I don't know the exact number, are saying that indeed they saw him there. This is an issue that will be brought, I'm sure, before the committee. I'm not don't have personal knowledge, so we will not be testifying on that, but that's essentially what's at issue. Well, she makes a lot of presumptions. Obviously, I have a family. I have my own beliefs on my own religion. None of that's at issue here. And frankly, I mean, listen to the language of this caller. God, family, and country is a code word for the right wing. They think that they own it, as if none of the rest of us have an interest in our country, our religion, and our family. We all do. That goes without saying. And as far as representing that women don't have to get up and go to work, I mean, maybe she's privileged and doesn't get up and go to work in the morning. I happen to. I know that the majority of American women who are of not retired are working full-time for pay, and they have a right to decent treatment, not special privileges, just not disadvantages. I mean, let's face it, we're making 60 cents on the dollar. We do have a lot of laws that discriminate against us: pension plans, insurance laws, credit arrangements, marriage and divorce laws, and we have a right to expect that a judge, and certainly the highest court of the land, will treat us as equals and give us a decent break. We don't think that's what will be the case if, in fact, we go backwards.